and it is not about sharing with other people a way of looking at the world that is shareable, then you are the one building a basis for the inhumanity that makes the production of life easy and possible.
Yeah. Thank you so much, sir. Thank you. Mr. Papa, I'll come to you because I've been giving the work within the Nigerian literacy space. One of the students asked, what is the difference between disinformation and the truth? How do we keep the truth alive?
Well, that's the symposium, I believe, put together to celebrate the life of Nigeria's, in fact, Africa's literary icon, Professor Wale Soyinka, who is celebrating his 90th birthday. I'm sure that other events are lined up for that birthday. And TVC News will continue to cover it and bring you updates. We'll now move on back here in the studio to Standpoint. Now, we're talking earlier about the Supreme Court judgment on local government autonomy that has been generating conversations around the country. People are reacting to it, for and against it. We saw recently the former governor of Delta State, James Ibori, saying that it is not the right way to go. But let's get a fresh perspective on this from our lawyer, Olayinka Ola Daniels, who is joining us virtually. Good to have you join us.
Thank you for having me.
So let's get your thoughts on this. It's generating reaction for and against. I'm not sure, I don't know if you've seen the recent statement coming from the former Delta State Governor, James Ibori, also speaking against this particular judgment. Well, how do you interpret it?
Well, some of us, we must say that it's a welcome development for us. This is what we have been clamoring for a long time. And I will say that I am happy seeing democracy come into play. Anyone that is against this judgment and anyone that is not pleased with the situation at the moment is an enemy of democracy. And how do I mean? These people are selfish, self-centered. These people are, it is just a mischievous motive in every way that some people just want to ruin what a lot of people fought for over years. Why would someone not be happy that autonomy is given to local government? If we have three governments, we have the federal government, we have the state government. And the question is, which government is closer to the people? We all know that that is local government. Now, if state government is the one in charge of local government funds, now tell me, how will the people feel the impact? It is sad to see this play out, several years. Because that is when you see the state government doing whatever they like in the state and hovering around the local government and dictating who becomes the local government chairman or removing a local government chairman at will. And we talked about democracy. And we want democracy to grow. We can see that we talk about rule of law. And all the time, we talk about rule of law on paper. But in practical, we do not see rule of law. This is the first time we are seeing this. And I think it should be an applause to the Supreme Court. And it is a win to Nigerians. It is a win to the people of Federal Republic of Nigeria, except for a few selfish, self-centered individuals that think this should not go this route. Now, from the judgment of the Supreme Court, it's clearly stated, even the governor cannot sack a duly elected governor, local government chairman anymore. And just the fear some of us have in this regard is the pressure and the influence the state government and wherever the governor may have on the people to decide who becomes the local government of a particular local government so that they can still prevail over such person. so that they can still run the show from their seat. Why do you want local government to be paid into the state government, to the state government, so that the governor can dictate and determine what goes to what and to who? So to some of us, it's a welcome development, and it's a win for democracy, and it's a win for the entire nation.
But
and we want to see more of this coming.
Does this totally guarantee that the governors do not have access to these funds? Because one of the things that is also very confusing for a lot of people is a part of the Constitution, that's Section 162, that talks about the state joint accounts. And then I think, you know, I was trying to get it earlier. One part of it also talks about, I think that same Section 162, you know, that a part of it also talks about the money that accrues to the local government, you know, shall go to the state. And so people are wondering, what does all of this mean? Do the states still have access, or now is directly under the purview of the local government?
Well, that section is not ambiguous, and that's the truth. Section 160 is not ambiguous, and the only people that are mischievous are the ones that will start quoting that section as to say that, oh, no, the Supreme Court cannot give such judgment when the Constitution. Don't forget that Supreme Court is also saddled with the responsibility of interpreting the Constitution. Because some of us, we go to Supreme Court to interpret what we feel, what we see, we think is ambiguous, or what we think the position or the interpretation of that particular section of the Constitution is not clear to us. We go to Supreme Court for clearance. And this has cleared this. Now, when it talks about joint account, when it talks about, you see, it doesn't give, that section does not give the state government power to oversee, or doesn't give them power to receive the money meant for local government, and so that they can then decide whatever they want to do with the money, then give the local government peanuts. And the people that are close to the local government are suffering, and local government cannot do anything. So that section in no way is it conflicting with the judgment of the Supreme Court, except for the mischievous individuals that want to interpret what does not exist. It's not ambiguous. For state government, that section is clear on the joint account and what the state is supposed to do with such account. But not money that is that is meant for local government is received by state government. Then you really don't know where the money goes into. You don't know what the money is being used for. Then they have so much power to dictate who become the chairman. Then when they put the chairman there, then also they go ahead to dictate what the chairman does. They even give him rules. They give him what they tell him what to do. This is an elected officer.
And interesting, Mr. Laika Daniels, again, sorry to interrupt you, because you mentioned, which is, you know, the political side of things, as much as we're talking about the legal angle, the fact that the governors can dictate, you know, who becomes the chairman, that hasn't changed, whether by election or by selection. And by selection, that might have changed by selection, which is, you know, no more caretaker committees. But that hasn't changed by selection in terms of, election, in terms of who gets the ticket of the party. Most times it's those who are loyal to the governor. We've seen in a particular state where someone came out and said, oh, the monies that accrue to the local government, we are not getting it. And then, you know, that particular local government chairman was almost vilified. And we saw the other local government chairman going to beg, you know, the governor. It shows you the state of things at that level. Whilst, you know, legally, the governor might not have access. What about behind the scenes? If the local governments are now willingly say, oh, look, this is the post, you can have it.
Okay, let's look at it this way. You know, what you talked about has been happening over time because of this same bondage that the local government have found itself under the system that we've been running for years, from 1999 to date, to say that, okay, the state is the one that gives local government money, so the state decide. And that is the reason why you find out that in some states, other political parties cannot have a chairman in that state. Why? Because the running party, the running political party is in charge. So they determine who becomes the chairman because they are the one releasing money to these people. So that does not give other political parties play. It doesn't give them a room to say, okay, they want to contest for a political office under the chairmanship of local government. That is why in most states, you see the people in the local government from the same party. But with the judgment of the Supreme Court, with the new order, you will see things going different ways. It means that if the money is going directly to the local government, then the people then can decide. Then the political party can come and you can see through election in a local government that being run by other political parties can then be addressed and say, oh yes, we can actually come out to contest an election and not a selection. Because what we have seen over years has been selection from one political party selecting his own loyalty to become the chairman of all the local government in the state. And all of them go to kneel down before the governor and beg the governor for their food. And he gives them whatever, whether he's token, he just gives them, a carrot stick, he dangle a carrot stick, and nobody does anything. And he cannot go against his will because he's the Lord of Lords of that state. But in this new order, you will see that things will change because the people now, I hope that the people have an understanding that, look, the power belongs to the people. And the people can decide who becomes the chairman of the local government. Since the state is not the one giving them the money right now, it's coming from the federal, from the federal government, from the federal account. So the people, different political parties can then contest and hope to see a free and fair election. And we can even have different political parties becoming chairman of different local governments. And in this time, you then see that the people of that local government of the world, and whoever that's going to be a local government chairman, then should work hard to be a grassroots politician so as to be able to convince these people and becoming the chairman of that local government, as against the governor dictating whatever it is to them. So it will be.
Is that even possible, Mr. Ladaniels? Is that even possible when you consider Section 197 that gives the states the power to organize their own elections? It's again where that situation where for the SIEC, it is the governor who appoints the chairman of the SIEC. And so if the governor is saying, I am appointing you as a chairman, and you do not have someone who has the boldness to say, I want to conduct a free and fair elections without the interference of, the state architecture, are you not going to have, again, an issue, or a situation where it looks like an election, but it's just a glorified selection?
Very well, thank you. We can all see today what is happening. In a state, election is being conducted even at the federal level. You see election being conducted, and some parties that are not pleased, approach the judiciary for redress to say, look, and we have seen situations where the court has changed the pattern, has moved from one party to the other. Oh, this election was rigged, or this happened and all that. So let's say, assuming without conceding, yes, the governor has appointed the ISEC chairman, and he's saying, look, we need our people in those places. Of course, if the people had come out, look, election is being rigged because people that are supposed to come out and vote sit back in their various homes, and they're able to manipulate the number. And then you come back to say, oh, so number, then there is an issue. But if people come out to vote for their own, and that election is being rigged, and whatever that has happened is not going through the route that should go, then everybody, anyone that is not pleased with such, can approach the court. And having said that, don't forget that there are a lot of work on the Constitution that some of us have been clamoring for. There are a lot of amendments that because we don't even, we are approaching, we want a situation where the governor will not have power to elect or nominate or appoint the ISEC chairman. We want a situation where even now, the state will not be the one conducting election for local government chairman. Let it come from INEC. So these are things to be done. These are the amendments that are required under the Constitution. We know as it is today, but even the way it is doesn't mean that if election is rigged, if the ISEC is a loyalist of the governor, the ISEC chairman is a loyalist of the governor, does not automatically guarantee that they will have their way by saying, okay, we want our candidate as the chairman. If the people didn't come out to vote for such person, if they choose their party and their political party, we have seen instances. How come in some wards you see another political party winning in some other wards as against some other wards? So it's still happening. The same Lagos State, you remember during the presidential election in this same Lagos State, we saw the votes that went to other parties. And don't forget that people were here in charge of it that are loyalists to the governor. We saw what happened. It doesn't mean that the other political party cannot still get whatever, they work for. If truly the people are come out to vote for a particular individual, it doesn't mean that they can't get it because the governor has appointed the ISEC. Of course, they have another place to seek their redress, which is the judiciary. And I don't think judiciary will compromise. And also being loyalist to the governor, if something is clear, if you have your facts before the court, your evidence is clear before the court, I don't think court will look away and go the other way just because they are loyalists to the governor or the governor appointed them. So things are changing. It's a gradual step. But that's why we are saying it's a win for democracy. And from here, we take the next step and we will get there someday.
Let's also talk about the other part of this judgment, which is the caretaker committees. For the 21 states in the country as of today that are running on caretaker committees, what is the implication of this judgment for them?
I think the implication of that judgment is clear. It means that immediately anything on caretaker ceases not to exist. And anything on caretaker now is tantamount to illegality. It is void, and the next thing that should happen is immediate alacrity for the state government to conduct local government election in all those states. And the so-called caretaker people should vacate the seat immediately, because that is the judgment of the Supreme Court. So anything outside that, anything contrary to that, it's against the rule of law and it's against democracy. So the implication of this is, with that judgment, immediately anything caretaker ceases to exist. And we cannot tolerate caretaker again. And thank God for that judgment. It will no longer exist. I think the next action should be for all those states, for their government to conduct local government election and have a proper elected local government chairman in all those states.
So let's talk about Rivers State. Let's talk about Rivers State in the light of this. Rivers State governor has said that he is going to conduct elections in October. You see the tussle and the crisis has been happening at the local government level, where, for those whose tenure has expired, they say, look, the National State House of Assembly has elongated our tenure, but the governor has also gone on to sort of inaugurate caretaker chairman. Now that with this judgment, what is this between now and October? What is the state of the local government in Rivers State? Who is in charge?
Well, unfortunately, as it is now, in Rivers State, I think what is appropriate for the governor to do is to first remove those caretaker chairmen coming from the judgment of the Supreme Court and perhaps appoint an administrator. So no caretaker committee, no caretaker chairman, appoint an administrator to see, or whether the secretary, you may not even appoint an administrator because there are civil servants in the local government. Whether it's the secretary, the permanent, whatever, the most senior, to administer, well, we still call the person an administrator, to administer the local government, pending the time the election will hold. Because if you still leave the caretaker chairman there, or the committee, and you still call them by that name, it means that the judgment of the Supreme Court, which it is not good for our democracy, it means that the judgment of the Supreme Court is what? It won't hold water, and we can't afford that. I think the right thing for that governor is to dissolve that caretaker committee with immediate effect after that judgment, and have an administrator, maybe the most senior person in that in each local government, spending the time the election will hold.
And Mr. Latin, as we wind down this conversation, because we've talked about Section 162 and Section 197 of the Constitution, as we consider and as the Constitution review process is ongoing, do you think that, look, sometimes, because some people said, look, the letters of the law as stated in the Constitution is a challenge in terms of interpretation. When you talk about state joint accounts, when you talk about SIEC, and then, sometimes local government is not mentioned until much later, that some of these things should be fixed. Do you think that these are the issues that perhaps should come up in the Constitution review?
We have said that, absolutely. We have said that over time that our Constitution needs a total overhauling, if not jettisoning and having another Constitution. But what we have today, we'll keep having problems every day. We'll keep having issues of interpretation every day. We'll keep having issues of people with selfish motive coming to tell us what Constitution has said and what it has not said. Even what is not ambiguous, they will make it ambiguous. Until that repeal is done, well, if you look at it over time, we've been repealing the Constitution over time. There are some repeals, there are some amendments over time on the Constitution. So it's not going to stop. It's either we jettison this particular 1999 Constitution entirety and have a new Constitution entirely to administer to be the manual of the Federal Republic of Nigeria, or we continue to do a lot of work in amending, and I don't know how long that will be. I think the appropriate thing is for the National Assembly to sit together and let's start picking up on how to have another Constitution entirely to help us in our nation. Because, sorry, let me quickly state this on this local government. Now, Lagos State is peculiar. If you remember, we have local area council in Lagos State. Now, when the money comes directly to the 20 local governments, so what happened to the 37 local council area? So these are issues that we also need to address. And don't forget that those local council area has not been recognized by Constitution to say they are local government. So when money is coming from the federal account, it's not going to that 37. So what do we do in Lagos? Whether there are other states that have such situations. So there are a lot of work to be done on the Constitution generally.
Absolutely. Thank you so much for your time. As always, lawyer Olayinka Oladaniel. Always a pleasure to have you on.
Thank you for having me.
You're watching Standpoint.